Hello, everyone. I'm Raga De Silva. Welcome to Older Queer Voices, a podcast dedicated to amplifying the rich, diverse, and often underrepresented voices of LGBTQIA plus elders. In a world that often centers youth, we are here to listen to those who came before, the trailblazers, survivors, quiet rebels who shaped queer history simply by living their truth. Each episode invites you into a conversation with older queer individuals from all walks of life. Through personal stories, reflections on the past, and hopes for the future, we explore what it means to age as a queer person in a rapidly changing world. In today's episode, Protecting What's Yours, Legal Planning for Queer Elders, we are diving into something that might not seem exciting, but is absolutely vital: the law. For queer people, especially as we age, legal planning isn't just about paperwork. It is about protecting our identities, our relationships, and our chosen families. Shortly, we will be speaking with the legal expert Kirsty about everything from writing a will to setting up powers of attorney, planning for care, and making sure your wishes are respected, especially when your life doesn't fit into a traditional mold. Kirsty is a non practicing solicitor and has worked with the Association of Lifetime Lawyers as a legal consultant since 2023. I would love to welcome Kirsty now here.
Hi, Raga. Lovely to speak to you.
So good to see you, Kirsty. And I didn't say Kirsty and I didn't say your second name because I didn't know how to pronounce it. I should have asked you. How
Oh,
do
no,
you?
that's absolutely fine. Nobody does. It's Kirsty Limacher.
Oh, wow. Okay. But next time I should remember to ask. But welcome, Kirsty. And we're going to have a very interesting conversation. I know that just from the briefing we've had together, this is going to be very vital for us, for our podcast, and for a lot of listeners who want to know so much more. And today I've been ignorant about, they don't know what they don't know, right? We don't know what we don't know. That's the thing. So I hope that our conversation helps a lot of people from the community to understand this better. So let's start with what is very important is wills and inheritance and the importance. So from a legal standpoint, what are the key protections a will offers? Why do we need a will?
Well, we need a will because it puts you in charge of who looks after your estate when you die. Your estate is everything you own at the date of your death and who inherits from you. It gives you control over everything that you've worked for: money, possessions, digital assets, online legacy. Without a will in place, then the legal system will take over, and that might not reflect the reality of your life.
Okay, so without a will, so if I haven't written a will, or let's say someone dies, I pass without a will. So what really happens? And just give us a view on now that I'm legally married. That's one part of it. And if I wasn't married or I was estranged from a biological family.
Well, the law takes over. It's a set of rules called the intestacy rules, and they're very, very rigid. They dictate who inherits your estate and who can look after your affairs when you've gone. It follows a very strict order of relatives. In a situation where you're married or in a civil partnership, then your spouse or civil partner will be entitled to part of your estate. And if you have children, they may be entitled to part, depending on how much your estate is worth when you die. But if you aren't married or in a civil partnership, then it will be children, then parents, siblings, grandparents, aunts and uncles, or their kids if they've passed away before you. And if you haven't got anyone in those categories, then your estate passes to the Crown. As I say, it's a very rigid set of rules, and it completely leaves out of the equation unmarried partners, friends, chosen family, stepchildren, children you haven't adopted, even your favourite charity, for example. And even if you're estranged from your family, it's their legal relationship to you that dictates them inheriting, not how close you are to them.
Okay, so everything needs to be on paper, basically. That's what we're saying. And if it's
Yeah.
not paper, one automatically, like you, I'm just trying to understand. So automatically, I've got no paperwork, I've passed on, then the first right to my estate or whatever assets I have goes to my partner or and the children then, and then the extended other family members. Now, can someone
Yeah, married partner or civil partner, but
okay.
not people that you might have been living with for a very long time. No, there's no concept of cohabiting partners having a right to inheritance under
Okay.
English law.
Wow. Can someone contest that once I've passed? My siblings cannot take it, but I have the right to it, not you, not your partner.
They can do, but they have to establish that there's some way financially dependent on you, and that they should have been looked after, and we're relying on you to support them. Generally speaking, siblings, for example, that you have no relationship with and no financial maintenance for, wouldn't be successful in the claim. You can't stop people trying to make a claim, but whether they're
Sure.
successful or not is another thing.
And is it a huge hassle?
Dying without a will?
Yeah, like for the person who's left behind, is it a huge hassle, or is it a simple? I haven't left a will. My partner then goes and contests and says it's mine. We live together, proves that we live together for 20 years or 5 years, whatever. So, is the process very difficult and cumbersome, or is it a simple process?
It's difficult and expensive. If you're in a situation where you've been living for someone for 20 years, as I say, if you're not married or in a civil partnership, then the law just doesn't recognise that. You would be entitled to make a claim against their estate, but it's expensive, it's time consuming, and it causes an awful lot of hassle at a time when someone's already grieving and they should be concentrating on dealing with their grief rather than the admin of trying to sort out someone's
Sure.
estate. It's difficult.
Yeah, sure, sure. I was just wondering, in our community, the LGBTQIA community, it's not often the biological, people who are related to you by birth. It's by blood. It's not those families. Sometimes we have chosen families who we think have done much more for us than our own family. So in that case, is there any legal protection there? If I don't have a will, and if I have a will?
There isn't. No, the only way to ensure that your chosen family and long-term partners that you aren't married to or in a civil partnership with are protected is to put a will in place and state your wishes up front.
Wow. So do you find that in our community, the LGBTQIA community, our clients, our people face unique risks around inheritance, for instance?
They do. They face many of the same issues as anyone else, obviously, but often with extra hurdles to overcome. We've already talked about disputes from biological family, whom perhaps they haven't seen for many years, failure to update wills after transitioning, breaking up with partners or forming new relationships. Quite often people within the community don't realise that long-term partners don't have any automatic rights if they're not married or in a civil partnership. And another level of complication is children that are had through, say, IVF or surrogacy, which comes with its own set of complications re legal parenthood. That's, again, something not everybody always thinks about. That's a topic for a whole other conversation, though, and
Sure.
comes with its own difficulties.
Sure. Because I know of a couple, and I mentioned that to you last time. I know of a couple, they've been together for about 45 years. One is of South Asian origin and one is from here. They built assets together. They created a little love nest, between themselves. Both of
Yeah.
them equally, they were both working, equally responsible for building the assets. And then the partner who was born and raised here passed away, the English partner. And our South Asian man became homeless over time because the legal siblings of the blood siblings, let me say, contested this, and it was a really bad time for my friend, and still doesn't have any protection, no home
No,
anymore.
unfortunately, that's far too common a situation. It's very difficult when you've fallen out with biological family. I mean, they can agree to essentially put what would have been the equivalent of a will in place through something called a deed of variation. But if you've fallen out with and aren't on good terms with family members, then they're not going to agree to that. And as I say, going through the court process of making a claim against the estate, it's expensive and time consuming.
Sure. So, which means the first lesson we need to remember, the first insight is that having a will is very important and it's not expensive. I've been through the process, but it is so important to make sure that we protect our loved ones when we are gone. It's as simple as that.
Absolutely,
Yes.
absolutely essential.
We were doing our first episode conversation last month, and one of the things that came up, Kirsty, which was very interesting, is that people didn't know that you needed paperwork to take decisions on behalf of your partner in terms of when you have financial or when you have medical issues. So can you take us through that, the
Yes.
power of, and I heard that word called power of attorney, and I'm just saying, for us, how does that work?
Right. Well, there are two types of powers of attorney. They're called lasting powers of attorney. They both involve appointing trusted people to make decisions for you when you're not able to. But the two types, there's one that deals with financial matters. So that's things like bills, bank accounts, benefits, even selling property. That type can be used by your attorneys when you still have capacity with your authority, but you remain in charge of the decisions. It also crosses the bridge when you can't make decisions for yourself. And the other, a health and welfare power of attorney, covers decisions about your daily care, medical treatment, who you see, where you live, who visits you. That kind of LPA can only be used if you lack capacity to make the decision in question. And as you'll appreciate, it's a very grey area. You might be able to make decisions about some aspects of your personal care and not others. So essentially the two types, one covers who manages your money and the other covers your body and well-being, and you get to choose who makes those decisions for you.
So this is just for me to understand again. So these LPAs, if we can call them, lasting power of attorney. So LPAs basically are something that you require when you're present, when you're alive, right?
Yeah,
It's not after you go. So it's that paperwork is important to keep handy and ready for both partners, if you're in a partnered relationship, of course. And
absolutely.
yeah.
One covers up to the date that you pass away, the other covers after you die, and they go hand in hand and cover all of your decisions before and after you pass away.
So if one of the partners over time, for instance, I know of this case where one of the partners had Alzheimer's, got into a state where couldn't remember things over time. So they're mentally incapacitated. So this covers that part as well.
It covers that as well. It covers the bridge when they can't make decisions for themselves, so that the people that they've chosen and that they trust, who know them well and they trust to respect their wishes when they can't make decisions for themselves, can do so in their best interests.
Okay. So if I'm in the hospital, let's say in a situation where I'm very unwell, I'm ill, things are not looking good for me, I'm in a hospital now under medical care, and I want the doctors are asking, questions on what next. Can my partner make a decision on behalf, or the person that I've given the authority to make a decision, a medical decision on behalf of me with this paperwork?
They can make decisions for you. The doctors and medical staff will ask about decisions if they've got the authority to do so. They can't override medical opinion, because at the end of the day, medical decisions come down to doctors in deciding what is the best care for you. But the difference between having an LPA and not having an LPA is that the people that you trust, long-term partners, etc., might not even be part of that conversation, or they could even find their views being overridden by, say, biological family members who are, strictly speaking, your next of kin if you
Yes.
aren't married or in a civil partnership.
Sure, that's an interesting point. So let's say I'm again working out a scenario. Either I'm single and I've given the authority to one of my siblings or a chosen family, whoever it is. So they will be there with that paperwork, making sure that if they have to make decisions or have to have a conversation with a medical practitioner, that the practitioner knows that there is this person authorized to do so. Correct?
Yeah.
What if?
Exactly, and that can
Yeah.
even be things like life-sustaining treatment decisions. It can go quite far, so it's really important to choose someone that you trust implicitly.
Sure. But in a situation where that is in place, either it's my partner that I've given the paperwork to, the LPA to, or it is a chosen family friend, whoever I've given the paper to. However, if someone from our family, the blood family, the natal family, if they dispute this and they tell the doctor, no, I am the brother or sister or parent, whatever, I need to make that decision. Can that also happen? That situation can also happen.
If you've got an LPA in place, no, you've chosen who you want to make decisions for you. If they don't think that you're acting in your best interest, then they could possibly approach the Office of the Public Guardian or Court of Protection to say, I don't think that this is what they wanted. But you're pretty sure, unless they've got very strong evidence that that's the case that they're breaching their duties as an attorney, for example, then they don't get to say, you've said who you want to make those decisions for you.
Sure. So in cases of LPs that we're talking about, is there anybody, do you think that is of particular importance for our community, the LGBTQI community?
Oh, it's vitally important. I mean, if you're talking particularly about health and welfare decisions, that can cover things like care settings that you go into and ensuring that you're receiving gender affirming care, for example, if for members of the trans community, and making sure that they're receiving the right kind of care that's appropriate for them. And if it's chosen family or a long-term partner that you've appointed, then they will know what your wishes are and will make sure that they're respected when you can't make choices for yourself.
Yeah, that's so vital, right? It's so vital. Paperwork is so vital, and I so want to reiterate on the podcast today, Kirsty, that we must make time for paperwork,
Yes.
and yeah, we must make time, because I've spoken to a lot of our friends after this and people we know, and this nobody wants to think that they're going to die. First of all,
No,
none of
no,
us,
they
none of
really don't.
yeah, none of us want to talk about that. No, none of us think that, oh gosh, one day we're going to go. So, and they say, but I love my people, my family, I love so much. Everything is going to go to them. I know that when I'm in a situation where I need medical help, I know my family will look after me. That's all fine. That's all emotional. That's all lovely to hear. From experience, I know what is important is have your paperwork in place, make choices, make decisions that look after you and protect your family and yourself. Yeah.
Oh,
So
if it helps at all, I think of lasting powers of attorney like an insurance policy against ill health. You really hope you never need to use them, but if you've got them in place, then if the time does come when someone needs to make decisions for you, it makes life so much easier. Without them in place, the alternative might be a very lengthy and expensive application to the Court of Protection, which nobody wants to deal with.
that's well said. I mean, I'm sure people will remember the whole insurance analogy. Yeah. So yeah, insure your life, insure yourself. It's the best thing to do. And I'm going to go into the next track on relationships and legal recognition. As you know, legal recognition can shape everything from who makes medical decisions, which we talked about, to who inherits your home. But many in our community form relationships like non-monogamous relationships and
Yeah.
partnerships. We have chosen families we just talked about. So, why is civil marriage important, or a marriage important? What are the legal benefits?
Well, being married or in a civil partnership do give you some automatic rights. Whilst obviously I recommend putting a will in place, if you don't have one, then spouses and civil partners do have some automatic rights to inherit from you. They're treated as next of kin when it comes to making medical decisions, so their voice will be heard and can't simply be overridden by biological family members. It can confer other benefits like pension benefits, spousal tax allowances, inheritance tax exemptions that aren't available to people who aren't married or in a civil partnership. So it gives certain kind of protections automatically that you wouldn't get from a long-term cohabiting relationship.
So what happens when somebody has multiple marriages or civil partnerships? There's a new thing now, not new thing, but yeah, people do separate and do get divorced. And apart from just having non-monogamous relationship, we also get into several sometime married relationships, or like I said, civil partnerships. How does that work? Does it get complex?
It can get complex. Usually, if you've been married or in a civil partnership and that relationship is dissolved or you divorced, then that will cut off the automatic rights to have claims against someone else's estate. I mean, obviously, there's exceptions to that if you're providing maintenance for somebody else or they've got a right to your pension as part of the divorce settlement, etc. But usually, it's the cut off. But it can get complicated if, say, you've got a legal marriage to one person and a long-term partnership with somebody else. At the moment, there's no legal recognition within the law of polyamorous or ethically non-monogamous relationships. Only one legal spouse or civil partner is recognised at a time. You can have blended families, multiple partners that are all in a relationship with other, kitchen table poly, where it's solo poly, where you've got multiple individual relationships. So it can get really complicated, but there are planning things that can be put in place to kind of circumvent that. You could be looking at things like trusts, life insurance, having more than one partner named as your attorney and your executor in your will and your lasting power of attorney. It's going to look different for each set of relationships, which is why bespoke advice is so important.
Yeah, I mean, it does sound. because our new family structures now, we've changed. It's not no longer just mom, dad, and a child, and two children, and five children, and pets, right? It's
Yeah,
multiple. So apart from just having polyamorous relationships, that itself is like it does get that structure gets more and more complex. But then we also have, and I know this from some of the cases in India, for instance, when they were fighting for marriage equality. One of the petitioners was talking about, why don't we have blended families? Why do we need to give anything, or whether it's decision making or money or asset or whatever, to our natal family who have thrown us out of the home? They've ostracized us. I want to give it to my partner who's and I've got multiple partners and their children, their adopted children. So how does the law view this blended family?
no, they don't. It's the law is very, very binary. I mean, at the moment, there isn't even really protection for cohabiting couples, where it's just one couple without adding other partners into the mix. There's no protection at the moment, which is why you need to put the planning in place with things like wills and trusts and life insurance and pensions to make sure that everybody that you are morally responsible towards and have a relationship with is protected in the way that's right for them. I mean, I've got a friend who lives in America. She's legally married to her husband, but he's also got another very long-term partner that they've been together coming up to 20 years now. My friend's been married 30, and he treats them both equally. They've got children from both relationships. They come together every Christmas and have a massive cookout with both families. But she's had to do some very, very complicated planning for their situation. She's an attorney herself, fortunately, so they've got trusts and wills and everything in place to make sure that both partners are looked after in a way that's appropriate for them.
Yeah, but this is a very interesting point, Kirsty, because there are relationships like that. I also know of relationships where they've been married twice. Now they're in a long-term relationship with a third person. They've had children from both the previous marriages. They're in a long-term relationship, another child, and then it gets more and more layered and complex. And it
Yeah.
is, I mean, if you're not an attorney and you don't understand law that well, it can get very complicated, right? But by having an LPA, I mean, I'm just going back to the will. Will is fine. I've written it. I've given
Yeah.
my asset to people, very clear. Whoever I want to give it to, two wives, three children, that's fine. But what happens in an LPA? Can you give it to, multiple? Can multiple people in your life have an LPA in their name?
Yes, and absolutely. I mean, we normally recommend not having too many cooks spoiling the broth. Having multiple attorneys can cause just as many problems as not having any. But if you've got 2 or 3 partners and you want them all to be involved in decision making about your finances and healthcare when the time comes, then yeah, absolutely, you can appoint all of them.
And you can have multiple lawyers, you're saying, for three different people, three different solicitors or lawyers. That can also happen.
Oh, when I'm saying attorneys, I'm talking about the attorneys that are
Ah,
appointed under a lasting power of attorney who make
okay. So,
decisions for you. So yes, so if you had 2 or 3 partners, you could have all of them that are appointed to make decisions for you.
have you ever been in a situation where you have multiple LPAs and then things have not gotten, got out of control?
Oddly enough, I've never actually had it happen with multiple partners. It's usually children that fall out with each other that can cause problems. It's part of the reason why we say think very, very carefully about who you're appointing to act for you. If you know that you've got 2 children that just don't see eye to eye on things, then maybe consider not appointing them together, because if they don't work together now, they're not going to work together later.
Yeah, I never thought of this. This is interesting. So two siblings given the LPA, and when it comes to making decisions, financial or healthcare, there could be an internal dispute. And oh my
Yes,
God, that's crazy,
it
isn't
can
it?
get messy.
Yeah, it is. It is bad. So coming to think about that, what strategies do you recommend for protecting such non-traditional relationship structures?
Well, as I said, you've got the option of wills. You can have multiple executors and multiple beneficiaries in a will and provide for them that way. It might be that some sort of trust structure, putting money aside for one of your other partners rather than in the will itself in a trust, might be appropriate. You can put life insurance in place. Depending on the way it's set up, that can often be paid outside your estate. and can be paid directly out to a beneficiary straight away without having to go through the will and probate process, so that they have access to money. Depending on your pension scheme, there might be the ability to nominate pension benefits to someone who isn't your spouse, but it is going to be scheme dependent, so you'd need to talk to the pension trustees. If you've got specific wishes around care, and you don't want to place the burden on anyone in particular, you can write an advance statement about the kind of care that you want. It's not legally binding in the same way as a lasting power of attorney, but care providers will take it into consideration in providing care to you. But basically what you're going to need is some bespoke advice that fits you in your circumstances, to make sure that everything that you've got in place works for you and obviously is as tax efficient as possible too. So essentially, the law hasn't caught up with the way our community lives and loves, but that doesn't mean that we can go without protection. With the right planning in place, we can make sure that our families and chosen families are respected and protected.
Sure. I'm going to delve deeper into this little complex structure that we have. But what I'm curious about is the legal barriers for LGBTQIA clients, right? So for many of us from the community, the legal system hasn't, like you said, one, it's not caught up. Two, it isn't like that safe or affirming place. Whether it's fear of discrimination, misgendering, I mean, that's a big topic in itself, or being dismissed. These concerns have not gone away. They don't go away with age. So it just kind of gets worse and worse for some of us, right? So how do you approach creating a safe, affirming space for queer clients? How does it all work? How does it all come together?
Yeah. I mean, you're not wrong. There's still an awful lot of fear and mistrust when it comes to getting legal advice. And that's quite often, as you say, shaped by past experiences. For me, when I was practicing, it starts with listening to the people that are in front of me and not making any assumptions about their life and their relationships. I tried to create a space where my clients didn't have to justify who they love, how they live, how they identify. That shouldn't be an extra. That should be basic dignity for the clients that you've got in front of you. So we can ease fears of our clients by checking names and pronouns without assumption, using inclusive language, and that should start with inclusive documentation from the very start of the client's interaction with the firm. I've always said to people, don't assume the relationship between two people that come in to see you. They could be partners, they could be married, they could be siblings, they could be father and son, they could just be business partners. I always just ask a very open question: how are you two related to one another? And let them tell me in their own words. And that I've usually found that works quite well for being open and honest. And basically, it's about creating a space for honesty. Sadly, a lot of queer clients still carry a lot of shame, fear, and trauma from their past legal experiences. So we need to overcome that and show respect to the clients when they're coming in to see us, and give advice based on circumstances without judgment.
That's fantastic, Kirsty. So are there specialist LGBTQI plus lawyers, or every lawyer is sensitized,
There are some specialist LGBTQIA plus lawyers, not that many, but you don't necessarily need someone who's a specialist. What you need to be looking out for is someone who has got the right kind of indications on their website, for example. So you're looking at who mention LGBTIA inclusion, chosen family, blended family, non-traditional estate planning, and the places that you can start with that. Obviously, I'm working with the Association of Lifetime Lawyers, and they have a Find a Lawyer service, and I have provided training to our members on LGBTQIA plus inclusion. There's the Law Society's Find a Solicitor tool. I'm also the Vice Chair of the Law Society's LGBTQ plus Solicitors Network, so you can approach them for any recommendation. And if you've got access to LGBTQIA plus legal networks or community centres, they might be able to provide you with recommendations as well. So it's not necessarily a specialist that you need, but you do need someone who is aware of the issues and you feel comfortable talking to.
Sure. And if there is a certain level of discomfort, or someone has misgendered you, or hasn't understood your case, you have places where you can go for redressals, or
Yeah, you can go for redress. Obviously, it's the easiest thing to do is to deal with it there in the moment. I know it's not always easy to do. Just a quick reminder, I'm sorry, but my pronouns are they, them, for example. Usually, the right people will apologise. I'll get it right next time, and that's it. If it continues to happen, you might want to think, is this the lawyer for me? And perhaps think about going somewhere else.
Yeah. So I guess this is in any other case as well, right? Not just an LGBTQI case. If the person
Oh,
doesn't fit, yeah,
absolutely.
yeah.
Yeah.
You know, I've got a few questions on the transgender community as well, which I want to talk to you about soon. But I have you ever seen any cases, where the LGBTQI people were excluded or overridden due to lack of legal documentation? Can you cite an example, for instance, and how did you manage that?
I've not dealt with any directly, but it can, a lot of confusion can come. For example, if someone has changed gender since they were provided for as a beneficiary in a will, or if they've been named as an executor in a will and they've changed gender since then. Usually, if you can specifically identify them as being one and the same person, then it should be okay. This is why I always recommend to people, whilst not wishing to give themselves away or dead naming themselves, keep a trail of documentation, things like changed birth certificates, deed polls, gender recognition certificates, so that you've got it all together so that you can prove that you are still the same person if and when it needs to be. It's a matter of personal choice as well when it comes to writing your own will. Lots of people wouldn't want to do it, but you could put your current name that you're currently known as and your previous name in the will as well, just to make clear that link. If you don't want to do that, and I can quite understand why people wouldn't want a previous name on their will, just keep the documentation safe with a copy of the will so it's clear that you're one and the same person, or even a little letter written with the will explaining the difference.
Yeah, because I've heard stories, horror stories of the trans community from the community that when their friend has passed away, the tombstone dead names them. So I mean, how do you protect that?
It's very difficult, and part of it comes down to making sure that you've got the right people who are acting for you when you pass away, so the executors are right. I believe that there is provision, even if you don't have a GRC, to get your death certificate with the right gender marker on it. I think it's relatively new though, but I can dig details out about that if they
Yeah,
want
and
to
we'd be
share
happy
that.
to update it. Yeah, on our
Yeah,
YouTube, because I think that's really important. And I have a lot of transgender friends from the community here in the UK and also from India, and I know the pain that they go through. And so, what legal challenges do the transgender clients face around gender GRC, the gender recognition, or name changes, especially as they get older? A lot of people come out much later in life as well these days.
they do. Yeah, some people might have legally changed their gender with a gender recognition certificate, but lots of people won't have done for many reasons. That can be past trauma, fear of medical gatekeeping, systematic barriers. Whilst people talk about obtaining a GRC being a simple process with, I think it used to be a £5 fee, it might have gone up to £6 recently. I know from family and friends that it's not a simple process at all, and it can take many, many years to obtain a GRC, and some people just don't want to face the
Yeah.
scrutiny and the trauma that will bring. So things like name changes by deed poll are much easier to achieve, but still might be misunderstood by people. Even with a change of name, it might not be reflected in all legal documentation, so you might be going by a particular name on a day-to-day basis, but still have things like passports or driving licenses or pension provision, etc., in the wrong name, which is why I say it's so important to keep a little folder linking everything together to show that who you are. But I suspect a lot of the problems will come up if you don't have a will and LPA in place, possibly through malice from family members who are just homophobic or transphobic, not wanting to honour and respect your wishes, which is why it's so important to choose people to help you who will do.
Yeah, and we have to remember that there are a lot of people from our community who are ostracized by their families, sometimes even
Absolutely.
by friends. They're
Yeah.
they're alone. They're just by themselves, and it is harder, I'm sure, for them when things happen and they, need medical help. And then you have all these issues of complex issues of legalities which they may have or may not have put into action. So, and that's another, I think, another one our conversation, isn't it, on how we manage that, because I've seen this happen so much. And if I didn't have family support now, I don't know what I would have done. I probably would have been one of those people, quite shameful, carrying a lot of guilt and just doing my own thing and thinking life will sort itself out and death will sort itself out.
I mean, there are support services out there, as you know. There are community groups and there are charities that can help. There aren't many of them, but there are LGBTQIA affirming care homes and retirement communities that people can go to. So there are resources there that can help, but there is a real loneliness epidemic, not just for the LGBTQIA plus community. As people get older, loneliness is a big problem, and seeking out support and help in those circumstances is so important.
This is what I'm was going to talk to you about next, is about older healthcare and protection, which is very, all of us, if we have the privilege, we will get old. So
Yes, yes, it's
it's
inevitable.
yeah, yeah. So I'm getting there. I'm not still there. I'm getting there. I keep on saying that to just make myself feel good. But no, so I have the privilege of getting older, right? But I also know of situations when, I'll give you an example. My partner had a brain injury 4 years ago during lockdown, in the middle of the night, wheeled into the emergency. Very fortunate. Wheeled into the emergency. Within 15 minutes was there. Things were happening. And then one of the doctors asked her, should we call your boyfriend or your husband? So that's
Yeah,
the first thing. She said in that moment when she knew something was really wrong with her and she didn't know whether she was going to come out of it alive, she was too worried, too scared. She said, should I come out now? Because my life is in their hands. Should I just let it go, or should I come out and say, no, I've got nobody, or my boyfriend will be waiting, this is the number, you know? So this is only one instance. Then there are many other instances where people have gone into care homes, older people, and whether it's trans people who've had to, they get misgendered all the time, or a friend of ours, or someone we know whose partner was in a care home, and they just completely, he's a black man who was with a white man. The white person was in the care home, and the care home completely refused to accept their relationship. They would call them
yeah,
father, son, brothers, when they're not even, like, just like Nicola and I, no, we don't look like sisters. People call us sisters sometimes just to make themselves feel better. And then Noel, who was in the hospital, in the care home, Ted would go and visit him, and he would find burn marks, cigarette burn marks all over him, abused, marks of physical abuse around him. And then the care people would say, oh, he did it to himself, he's so aggressive. And in the end, when he finally passed away, Noel, it was very difficult to find the body, because they didn't acknowledge Ted. So I'm saying
yeah.
that these things are happening in care homes as well. How do we find protection against this, first of all?
Well, the first thing, as we've talked about already, is setting up a health and welfare LPA. It gives your partner and your chosen family the voice so that they can make decisions for you and advocate for you. They know and understand your gender, your identity, and your values, so they can make sure that those are communicated to the care home. If there are issues of abuse, they will also then be able to speak out on your behalf if the person who's in the home themselves doesn't feel comfortable to. As I said, they're possibly not as common, but there are LGBTQIA plus affirming care homes out there that might be a possibility, and retirement housing. If you've got particular feelings about how you want to be cared for, you can write an advance statement setting out your care wishes. And that can include things like pronouns, gender identity, who you want visiting you, who you don't want visiting you, types of care settings and cultural values that matter to you. You can keep your medical records updated. Make sure that that's updated with current name, pronouns, gender identity. If you've got a health and a welfare LPA in place, I've always said to clients, let your GP know so that it's noted on your medical records. Everything being centralised these days, if you do find yourself in a hospital setting, that should come up on your NHS records if it's been noted on there, and they'll know that you've got an attorney that can come in and speak for you if you aren't able to do so.
And what if it doesn't come up on your medical records? So I've made the decision. I have given the authority to someone in my family or a friend. I've got all the paperwork done. I have an LPA. LPA is in place. By the way, in Ted and Noel's case, they had everything. That didn't work at all. Just say in that case. So I don't know how to manage that, and we'll talk about that as well. So
Yeah.
I've got everything in place. Now I'm at the hospital. My partner's in the hospital, or I'm in the hospital setting. I need help. How do I ensure that all the information that I have given, whether it's to the GP or to a friend in that paper LPA, how do I make sure that that is utilized on my behalf?
Well, if you've got capacity to tell the staff yourself when you're in that situation, obviously you need to speak up and make it known that I've got this paperwork in place. Please call this person. I know that certainly on Android phones, you've got the option to put an in case of emergency contact in, so that even if you aren't verbal and can't say for yourself that this person needs to be contacted in an emergency, you can put the information into your phone. And I'm assuming that the same applies for iPhones, that is available. But if the hospital staff aren't listening to you and won't honour your wishes, it's a very, very difficult situation. I mean, obviously you need to make a complaint to the hospital in those circumstances, but in an emergency situation, it's a very difficult thing to have to deal with.
And what happens if a certain care home has been, you've been put in a certain care home, and that's not the kind of care home you want to be? Do you have rights? I mean, do I have rights as a person who needs the care to say that I don't want this, I want to go somewhere else?
Oh, absolutely. If you've got capacity to make decisions for yourself still, you can't be forced into a care home that you don't want to be in. You absolutely should be advocating for yourself and saying, I don't want to be here. The practicalities of moving you will have to be looked at, and it will have to be managed carefully. But if you've got capacity to make decisions for yourself, you can't be forced to be somewhere that you don't want to be.
Yeah, okay. So that's good to know. So you have that right, and you have that protection legally as well.
Yeah.
Right. So elder abuse it seems to be a big
Yes.
thing, right, in care homes, and not just in the LGBTQI community. In our cases, I've heard of a story of a trans person, like I said, who was in a care home recently, and they were misgendered. They had to come out and had not been through transition, but had lived as a woman for 20 odd years, and it was very difficult, and they had to go back to their biological gender. So that abuse, that's a form of abuse. Then there's another form of abuse, which is physical abuse as well. And so how do we protect our elders, in terms of the law?
I mean, there is a statutory act in place, the Care Act 2014, and that includes protections against neglect, financial abuse, coercion, everything like that. But the steps that you can take is to set up lasting powers of attorney for property and financial affairs and for health and welfare, to make sure that people you trust can make decisions for you and have a voice. Make regular financial checks part of the routine. So even if it's not you yourself checking, make sure that somebody's checking for you. If they're your attorney, that they're on top of that. You can involve more than one attorney under powers of attorney where possible. Obviously speak to a lawyer or even your GP if you feel at risk, and they can flag concerns. I mean, the sad thing is that abuse is quite often silent, especially things like financial abuse and physical abuse. The people being abused often are the ones that end up feeling the shame. They feel like they've done something wrong to be deserving the abuse, and it can be very, very difficult to speak up. But if you've got attorneys in place that can speak on your behalf, it can make things very much easier. So basically setting up safeguards now so that you've got someone who can advocate for you when the time comes is the best protection against abuse. But it's so very hard. What you said about people, I don't like the phrase, but going back into the closet, people quite often do in care home settings because of the attitudes from staff. They're scared to come out, and it's just easier for them to, I don't want to say revert to a former gender, but to say that they are their former gender, or just not to mention that they're queer in any way, because it feels safer to them, which is incredibly sad.
Yeah, and we've heard a lot of instances of people going back into the what they call the care closet, right? Don't
Yeah,
want to come out in a care home because of exactly the reasons you mentioned. You said put safeguards in place now. So
yeah.
can you list out like some of the thoughts you have on safeguard? What is it? Is there a checklist that we can follow or we can give to our audience?
So safeguards in place now. Obviously, you've got LPAs, both types, property and financial
Yeah.
affairs, health and welfare. If there's particular kind of care that you want, you can write an advance statement that sets out name, pronouns, type of care that you want to receive, things that you don't want to receive. There's something slightly different called an advance directive or a living will. And if there's particular treatment that you don't want to receive in certain circumstances, that would be legally binding if it's written in the right way. But you have to be very, very careful if you've already got an LPA for health and welfare in place that they don't conflict with each other, that a lawyer would be able to advise you on making sure that that doesn't happen. But the really important thing is making sure that you've got people that you trust who have got the authority to speak on your behalf.
Yeah, and what happens in one, there are lots of questions coming to my mind, but very important is what happens if you've given the LPA the authority to someone else, which is what we are talking about, but that person is then no longer alive.
Right, this is where the pre-planning comes in, because when you make an LPA, you can name several attorneys to act together at once. They can either make decisions on their own or they all have to act together. But there is also the ability in a lasting power of attorney to include replacement attorneys. So if the people that you've named to start with can't act for whatever reason, either they've passed away, as you say, or they might have lost capacity themselves, and you've got a second person or set of people that can step into their shoes. And again, that would be people that you trust to respect your wishes if the time came to make decisions for you.
Okay. So in terms of the will itself, like I said, it's a very important document. The will that we managed to get is a two-pager, which basically gives standard general. This is what will go. So do you think you need a lawyer to get a proper will, or if your life is a little complex, or do you just need a simple will in place?
Um, the problem is, as you've said yourself, you don't know what you don't know. The amount of people that I've spoken to that think they only need a simple will, and then you ask them a couple of questions and you realise that it's not quite as simple as they thought it might have been. My advice is always speak to a qualified professional when it comes to making a will. It's so easy to get things wrong just because you don't know what you're doing. I mean, I've even tested it myself recently with having AI create wills based on what appeared to be very simple circumstances, and the mistakes that were in the documents were from really, really significant mistakes down to tiny ones. But even something as simple as not getting a will witnessed correctly can mean it's not worth the paper it's written on. So wills don't have to be expensive. If you've got more complicated circumstances, it is worth paying possibly a few £100s to get something in place that protects you. Because if you don't have a will in place and it all goes wrong further down the line, then the litigation and the effects on your loved ones afterwards will be much more expensive than the little bit that you pay now to make sure that you're protected.
Sure. Because I looked at my will the other day after we decided to have this conversation, and I thought, like, this doesn't really say much. I mean, it doesn't really say things like, sorry, it just says that who will get, if something happens to me, then it'll go to my partner, and until she's alive. After that, it goes to the children. And so that's the only thing it says. It doesn't say who's to execute it, how are we going to execute it. It doesn't even talk about funeral plans, for instance. And a friend of mine who lost a father recently was talking about funeral planning, and she said, my dad didn't even do this, he didn't put this in place, so we don't know what to do. Like, mom wants something else, brother wants something else. So does that also come as part of the will, a funeral planning?
Yeah, it does. Most most wills will include some funeral wishes. The thing about funeral wishes, though, is they are just wishes. Your executors, the people that you appoint to deal with your estate, can override them. But if you choose the right people to act as your executors, they're not going to. But as you say, it can quite often leave people just a little bit in the lurch, feeling uncertain what their loved ones wanted if it isn't actually in the will itself. If you haven't got it in your will, though, it doesn't mean that it needs redoing and going in now. If you keep a copy of your funeral wishes with a copy of your will, just make sure that people know what you want. It'll make their life easy. And something that I've been saying to people recently as well, we live so much of our life online, and we've all got a digital fingerprint and legacy of some kind. So even things like finding online bank accounts, etc., if you make a list of everything that you've got and where to look for things, it makes it much easier for those that are left behind.
Yeah, it's another interesting topic to get into, because the friend of ours who lost their father, they're trying to find out all the basic information which we don't think of. How do I shut
Yeah.
my Facebook account? My social media accounts. What is my bank password? Simple things. So what is my power? This is the power I'm paying. How do I shut that off? So little things like that. Do they also, I know this is a very, I don't know, it sounds like a silly question, but does this all go into that paperwork as well with the will, that this is what you do to clean up after me?
It doesn't have to go on the face of the will. It sounds like what you've got is very simple, and it's quite often all a will say is that I want everything to go to this person in the first instance, and if they die before me, then to go to these people. And that's all the will itself has to say. But all of the background information about what you own, where it is, what social media accounts, etc., that you've got is really helpful, as I say, if you write a list of that for your executors so they know what to access. And with things like Facebook and I think Google, you've got the option of setting legacy contacts. I've done it on my Facebook account so that if I die before my husband, he can go into my Facebook account, and I've given him the option that he can either memorialize my account or delete my account if that's what he chooses to do. That's entirely down to him. Not entirely on the up and up, but I had a Facebook account for my poor late dog, and I memorialised that after he passed away with his cremation certificate. We perhaps shouldn't say that too loud, though, in case Facebook shuts that page down, so I won't reveal his name.
Yeah, sure. No, but these are what we think are small things, but they are
Yeah,
not small, right? They're important. They're a part of a legacy, as you said. It's who we are. And if when we
yeah.
pass, which we will eventually one day do, then what have we left behind for our the people we love? That's all that is important, isn't it? I mean, I would, yeah.
Absolutely.
Yeah. So if, as we end, Kirsty, is there anything that you want to share that you think will bring this all together and help our community in making the right decisions and protecting themselves and their loved ones?
Planning ahead, it's not just about death and paperwork. It's about dignity, making sure that the people that we know and love are the ones who carry out our wishes. The legal system as it is might not always reflect our lives as we live them, but with the right documents in place, we can make sure that we protect those that are left behind. One takeaway I'd say, it can feel overwhelming when you come to think about ill health and death. As you say, people do feel quite morbid when they're thinking about things like making a will, but you don't have to do it all at once. You can start with one thing, make a will, set up an LPA, even just talking to your chosen family about your wishes, but doing something today that you choose to do can make a huge difference to those that you leave behind.
Kirsty, that has been such a wonderful 50 minutes talking to you. Really, I've learned so much, and I'm sure our audience, when they listen to our conversation, will learn a lot. And we will make sure, Kirsty, between you and I, we have a little bit of a checklist that we can give. And
Excellent. Yeah.
yeah, so we can add that to our recording. And in future, if they want to reach out to any lawyers, any resources that you can provide, please just let us know, and we're very happy to put that forward on our YouTube channel, Spotify, and Amazon. Yeah, that'd be fantastic. And so, thank you very much. Very insightful session, and I'm sure we're going to invite you back again for more in-depth conversation on certain other parts of our LGBTQIA community and law. So, thanks for joining us, Older Queer Voices. Legal planning might not be glamorous, but it is a powerful way to protect ourselves and the people we love. Remember, your life, your relationship, and your wishes matter. So put them in writing. So and also thank you to our wonderful sponsors. And here they are. We've got Ageism is Never in Style. The Views Room is the producer. The Association of Lifetime Lawyers with Kirsty. Ragola, my G Work, Proud HR, and Outspoken Speakers. Thank you very much. And if you want to contact us to either partner, participate, nominate, share feedback, or have further questions for us, please write to us at theviewsroom@gmail.com. Until next time, take care, stay proud, and keep telling your story. That's from me. Thank you very much.